to Crime in Court. My name is Heather, and this is an update in the Sarah Boone case. So, we all know now she is her own ninth attorney. She had she had been assigned her eighth public defender, or well, no, she had some that one or two I think that she hired on her own, but the majority of the others were all public defenders. She had some issues with her eighth one, not a surprise because she was having a lot of personality clashes with other attorneys there that had been assigned to her, but not all of them were her fault, to be fair. Some had to recuse themselves for other reasons, so it's fine. Anyways, so what we're going to be doing today, um, kind of to go off of what I was saying, she is now her ninth attorney, and she has to write her own motions. So this episode of the Sarah Boone Suitcase M trial, Florida versus Sarah Boone, we're going to read through the motions that Sarah Boone has to give a try at writing. So we're going to see how well she does. She's not terrible. I mean, she follows the templates that she's seen in other motions. So, I mean, if you look at it, it's handwritten, but it's written like any other motion in the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, State of Florida, plaintiff versus Sarah Boone, defendant. She has all that written. She's got the case number. So, I mean, I give her props for doing things correctly. And we're gonna go over. So she recently put forth on 7/30, so July 30th, she filed these two motions. Or she sent them to the court, and the court files them for her. So she filed these two motions, and we're gonna read through. It's just like chunks. There's like a big 20 plus page whatever. So we're gonna read through this first one that she sent, and then we have a response to it. And then in part two, because this is part one, part two, we're going to go over her second motion, and then we're going to go over the hearing that just took place on this Monday. So don't go anywhere. Stay tuned to the channel. Please hit subscribe so you don't miss part two. And let's get started. Also, please hit that like button. It helps the algorithm, and I appreciate it if you do. So thank you so much, and let's begin. So, all right, so this is, as I said, oh, what page are we on? We're not even on the right page because I was scrolling through it. So, all right, so Florida versus Sarah Boone. This is a temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial. Comes now Sarah Boone pro se, which means she is representing herself. Indigit. I can never say that word right. Digent. Sorry about that. Indigent defendant. That's a hard one. Respectfully requests. Why is this being weird? That page is all gobbledygook. What the heck? Hold on. Sorry about that. I don't know why it did that. You guys all saw how it looked like gobbledygook, but now it's fixed. I had to close it and reopen it. It's fine. Something with the Adobe, how it like I think looks for words and can translate it. Although I didn't ask it to edit, so I don't know why I did that. But anyways, so investigator to be determined. So Sarah Boone essentially she's asking for money to be reserved so that she can hire investigators into her case. So she can hire, if she wants to do the battered spouse syndrome of defense, then she needs to hire some experts in that case or investigators to go and look for maybe Jorge, maybe she wants to look into Jorge's past, George's past, who she is alleged to have taken the life of. And I say that because she's not convicted, but we're going to after these two parts, I have a plan or I plan to put together just like a mashup of everything that we know so far. So like the 911 call, the body cam footage, um, what else? Her her interviews with police, which happen to be sort of confessions. So I'm going to put together like a mishmash of all of it together, and just because I think it's good to maybe revisit what to revisit all those things because trial is coming up in October, so we need to take a look at that. Anyways, okay, so she's asking for an investigator for how much or for who the investigator is. She says TBD, total amount, requesting TBD, how to calculate, unknown by defendant, reason, no discovery or case materials provided to defendant from the judge. So at this point, when she writes this, she still does not have the discovery. As we saw in a previous hearing, she was told that there's an intermediary that is going to be putting everything, copying and or scanning everything, putting them all into flash drives, thumb drives. So when she's at the prison, she can check out a computer and then she can use the thumb drives to look at her case. And that's how she's going to get discovery. She complained about that because she wants to write it on paper, and when she's up at 2 in the morning, she wants to have access to it. Judge says, sorry, can't do anything about it. This is what you get. So, but at this point when she writes it, she still didn't have this discovery, and I imagine it's probably going to take a while for them to get all of it to her, but they could probably start giving it to her in chunks. Anyways, all right, so this temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge and court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization from the judge and court. So she feels like she's being penalized or punished because whatever. Um, she doesn't say why, but she feels like she's being persecuted here. While she is on trial. So if she feels like she's on trial, that's probably why. All right, so while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. So as you can see, she's got to throw in some snark every now and then and like hammer home the fact that she is forced in this position now to defend herself and she doesn't know what she's doing. She needs help, judge. She needs as much deference that you can give her, even though she's going to kind of insult you in her motions as well by saying, I don't want to be persecuted or penalized anymore from you, judge. So, I mean, she's like totally calling him out. Like, I feel like you're punishing me. This is so unfair. All right, so I'm was being sarcastic. I don't think that it's necessarily unfair after everything that she's gone through with her attorneys and the repeated continuances of her trial. All right, so the exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced, all caps again, forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed with revised and resubmit this motion upon completion of her review and research of the contents. So she needs a little more time here, but to meet the request, judge, she is saying, to meet the deadline, I'm putting this in. I want it like it's a placeholder. Wherefore, Sarah Boone, pro se, indigent defendant. I want to put an N. I want to swap the N in front of the G. Indigent defendant. Wherefore, Sarah Boone, pro se, indigent defendant, respectfully requests to the Honorable Court to reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant's requests are in good faith and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her force. That's number 3 capital forced by the court to a position of pro se attorney and representation of self. Conclusion: this temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial should be granted. Oath. Okay, so she swears under I declare under penalties and perjury that I have read the foregoing document and well, she wrote it too, and the facts and matters stated are true. Sarah Boone. Certificate of service, blah, 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 blah. All right, this next one. So this is going to be a couple motions in one document. But we're moving along swiftly, so that's fine. This is temporary motion for reservation of proposed cost to acquire expert witnesses, multiple witnesses potentially for defendant's defense. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire expert witnesses for defendant's defense and trial. The witnesses are to be determined, total amount to be determined, how to calculate. She doesn't know. Discovery hasn't been provided. Temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge and court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization. Same thing. The exceeded time limit of waiting to receive the defendant's discovery and case materials again as forced. So she's going to repeat the same old, wherefore she is asking respectfully for the cost for the expert witnesses to defend herself in her criminal defense trial. And the defendant's requests are in good faith and her merits are worthy, blah, blah, blah. She says all the same thing under oath. And she signs it. These are all signed, what does it say, July 18th, by the way, or completed and mailed. So she mailed it July 18th. So it still has to take time to go through. Remember, there's no electronic way for her to do this, so she has to use snail mail and mail it to her to the court so that they can file it. All right. So it takes a little bit. This is the next motion, temporary motion for reservation of proposed costs to acquire all witnesses. So not expert witnesses, but any other witnesses that she needs. Let's see what she says. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire witnesses, all determined or to be determined, total amount requesting. This temporary motion is being submitted due to the delegated due date. The defendant is trying to avoid further persecution. The exceeded time limit of waiting, blah, blah, blah. She's forced. Wherefore, Sarah Boone, pro se indigent, respectfully requests money for her witnesses, which she doesn't actually give a good reason for. Is this like she's got to fly witnesses in, put them in lodging, even if they're not like an expert, maybe? I don't know. So that's what I'm thinking. She declares this under oath and it's certified. The next one, temporary motion for depositions to be conducted per Prop Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court. So she wants to do some depos. She has some people she wants to call apparently, and they're all to be determined. She doesn't give us any person's name, any schedules for the depositions, total amount requested, nada, to be determined. So this is, I'm sure, to reason defendant has been forced into the title and position of pro se attorney. Oh, maybe that's where maybe she did forced. And for no discovery of case materials have been provided to defendant by judge. Florida Rule of Criminal Procedure 3.220, discovery depositions, states, generally at any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. So does Sarah get to do the depo herself? I mean, that's kind of cool if you think about it. Like if you are your own attorney, easy for me to say, then you would be doing your own questioning of the witnesses, even in depositions. So that's kind of awkward, but also kind of cool as the someone who's sitting there in prison, and you get to go and do these depositions and like ask all the questions that you really really want to ask, and get, I mean, anyone other than Sarah Boone, I would say it would be a good thing, but she's going to have free reign to ask whatever questions she wants, which is probably not a good thing. But in normal circumstances, if you're your own attorney, I think that's pretty cool. They have to set up the depot. Well, you probably set them up, but through the prison system, you have to have they have to be able to come visit you at least, and then you would do it in a private room or something. I don't know. That'd be interesting. I don't know. It just made me start thinking about the logistics and whatnot. All right. In any case, no person shall be deposed more than once except by consent of the parties or by order of the court issued on good cause shown. So, like, if someone goes through a depot and they're finished, and then a few months later or years later, something comes out where you can prove that they were lying and they knew otherwise or something, some new evidence comes in, then you might be able to do like another deposition on that person to ask them questions about the new evidence, but probably not just because you're like, oh, I forgot some questions. Let's do this again. So, a witness who refuses to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena issued. The, def- the defendant may, without leave of court, take the deposition of any witness listed by the prosecutor or sorry, as a category A witness. After receipt by the defendant of the discovery exhibit, the defendant may, without leave of court, take the deposition of any unlisted witnesses who may have information relevant to the offenses charged. So anyone on the prosecutor's list, on the witness list, she can have a deposition taken or conduct a deposition herself. Or anyone that may have information relevant to the charges, to the offense. So maybe like a witness that the state doesn't know about, she could call another witness that they may not know but has relevant information. Discovery sanctions. This so this statute on discovery sanctions states if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such other. This is really long and I don't even know what it all means. So I don't know why she includes all this stuff, but okay. Number two, willful violation by counsel or party not represented by counsel of an applicable discovery rule or an order issued pursuant thereto shall subject counsel of the unrepresented party to appropriate sanctions by the court. Say that again. Willful violation by counsel not or party not represented by counsel and an applicable discovery rule. So if somebody violates a discovery rule, there could be sanctions, appropriate sanctions by the court, is what that's all this is really saying. But why does it have a party not represented by counsel? Because they could be sanctioned too if they don't meet discovery deadlines. But the sanctions may include, but are not limited to, contempt proceedings against the attorney or unrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate. So the judge knows all this, so why she puts all this in, I don't understand. And this isn't all necessary, I think. She should be saying why she needs to um, get this, why she needs this evidence faster, and why she needs these experts and whatnots. Um, I don't know why. Okay, instead of talking about sanctions and if she's trying to imply here, because she doesn't give it any context. So if she's trying to imply that the state is violating discovery rules, then she needs to say that, and she needs to give instances to go along with this. Otherwise, this could also be misconstrued as she's not following discovery rules because she's an unrepresented party. So, do you understand what I'm saying? She's like, she's not giving the context um, to make that make sense, why she's putting that in there. This temporary motion is being submitted to meet the delegated due date of 7/22 by the judge. Okay, the defendant is trying to avoid further persecution and she's being forced into this position. Time limit, she's forced into this, blah, 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 blah. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to the court to allow depositions to be conducted per FRCP Rule 3.220 by the defendant under pro se attorney title and position ordered by the judge in court and for her defense in her criminal case at trial. So, she also gave uh, law, written, statutes stating that, a defendant who is pro se can give any deposition. That's fine. Like, that's good. And that's the stuff that she needs. And that obviously, the judge can make sense of that. But when she throws in just like these random statutes without context around it, because any lawyer would put the context like, in this statute, blah, blah, blah. And this is why this is relevant to this case. They're going to bring it back around. So that's what she's lacking here. So Sarah, if you're listening, honey, not a critique. I mean, not like a negative thing, but I'm just it's a constructive criticism. Put in the reasons why those things are relevant. Just saying. All right. So the defendant requests in good faith all this stuff. Conclusion. Blah blah blah. Um, she asks that it be granted. She swears under oath. And that is the end of her motion, asking for funds, asking for um, the ability and funds to do some depositions. So, I mean, she kind of it's a good thing that she's doing this, and hopefully, I think the judge is probably going to give her a lot of, a little bit of handholding in like, you need to get me these things by this deadline, so that she can go and do the research on her own and figure out like, okay, I do need defense experts and whatever. So, and it'll help her in planning her case, in preparing for her trial. I am fascinated. Are you guys, but before I get into this next one, so this is actually the Justice Administration Commission's response to motions seeking due process costs. So this is an answer to Sarah Boone's motions that we just read through. But before I get into that, how excited are you guys to actually watch this trial? I mean, it's going to be very interesting. And this isn't like Daryl Brooks crazy. It's kind of like, you want to watch it because she is smart. Like, she's an intelligent individual. You can tell by the way she writes and the way she speaks. She has a vocabulary, and like I said, she loves to share her vocabulary with us and her large words and whatnot. Even if they don't all make sense in the sentence together, she likes to share them. So she's not dumb. So it's going to be an interesting trial in watching someone. on a, a at least, she's an intelligent human being and she's not crazy and she's probably not going to be like a Daryl Brooks where she's just trying to obstruct the entire trial and due process. But this, her eh, eh, writing these motions and things, I have a feeling she's going into it seriously and she's going to do what she needs to do to defend herself. What do you guys think? I don't know. I think it's going to be an interesting watch, regardless of what happens. All right, so comes now the Justice Administrative Commission, JAC, by and through the undersigned attorney, files this response to the above cited motions as follows. 1. The defendant is seeking authorization for various due process costs as follows. Appointment of standby counsel to assist the defendant, and we're going to get to that later because that's the other motion that she writes. Costs that we'll get to that in part 2. Costs to take depositions, an unspecified amount for a defense investigator, an unspecified amount for expert witnesses to assist the defense, and costs for unspecified witnesses to appear at trial. So perhaps lodging if there's people that are out of towners, or just whatnots. I don't know why else you would pay someone to appear at trial, like a lay witness, other than, travel costs and lodging and things like that. All right, number 2. As an initial concern, any future requests for due process costs, such as requests for transcripts, investigative costs, or experts need to be served on JAC prior to the court considering the matter. So she needs to start sending her motions regarding transcripts, costs, experts, those kinds of things to the JAC. The defendant is responsible for providing JAC with any motions for due process costs so that the JAC can respond accordingly to those requests. Perfect. Now she knows what she needs to do and she can do so. 3. JAC may only pay for due process costs pursuant to sections, all of those Florida statutes. Number 4, as directed by statute 27.425, Florida statutes, and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract policies and procedures. JAC objects to any compensation rate in excess of established rates. Whatever those rates are, okay, fine. Standby counsel. Number 5, as for the appointment of standby counsel, the court entered an order on June 28, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. And that is exactly the reason why she is now representing herself. She's too difficult to get along with any of her lawyers. Thus, the court has already ruled on the issue of appointed counsel. So that's said and done. They're saying, no, don't give her any standby counsel because you've already said she's not entitled to counsel anymore. Deposition related costs. Number 6, as for costs to take deposition, the defendant is authorized to incur costs to take depositions for those deposition authorized under the Florida Rules of Criminal Procedures. The notice of taking deposition substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. Number 7, as for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. So the sheriff, the county sheriff, the county that she's in, what county is she in? I don't remember. Um, they are, does it say? It should say Orange County. All right. So whatever county they're in, the sheriff needs to be the one to serve all of her documents here from here on out. So whenever she's got stuff that has to do with costs, she needs to send it to she needs to have it delivered to the JAC, but served through the sheriff's department. So, as for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. So, not even so even subpoenas or depots that she wants to take, she needs to serve those individuals. So that all needs to go through the sheriff also, unless they're not available. And then she can get compensated potentially through the JAC. The sheriff must be used to serve in county law enforcement. So, regardless of whether they're available or not, they will serve their own in county law enforcement if they're planning on subpoenaing or deposing any of them. All right, so number 8, as for transcripts, JAC has no objection to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, the date and type of hearing, and how is that not the same? The type and date of hearing, date and type of hearing, aren't those the same thing? And recording type and date of recording. I don't know. Okay. I'm losing my mind. The defendant should only order those transcripts necessary for defense of the case. Number 9, the uniform statewide rates are set forth as the General Appropriations Act. Court reporting services cannot exceed those rates. So they will approve whatever the um, standard is, and nothing more. All right, private investigator costs. Number 10, pursuant to the uniform statewide rates, the rates for investigators cannot exceed $50 per hour. Okay. And they know that. So anyone that is hired on by her, they know that going in. Like, that's their rate. They can't necessarily ask for more unless they have additional costs that are incurred. They might be able to ask for those things, but not an hourly rate. Can't be over 50. All right, so number 11, as required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services to be employed by an investigation agency with a Class A license. So those are the requirements if you hire an investigator. If the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. So the order needs to have a specific amount. It can't just be a TBD. Based on the docket, it appears Prison Break investigations Billy Lane may have already been appointed to this matter. Oh, so she might already have an investigator appointed, which is good. JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. So that's great. They're already coming out and saying, here's what we have no problem authorizing. If the court grants it, it's yours. Expert costs. 13. Based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. So that was going on behind the scenes from previous attorneys. JAC does not object to the court continuing this authorization now that the defendant is representing herself. Beautiful. Moving on. 14. As to other requests for other experts, the defendant will need to file an appropriate motion delineating the following. 1. Identify or type of expert, identity or type of expert. So if you need, let's say, a forensic pathologist, for instance, you might want to either find one and give their name, or at least say, I intend to get a forensic pathologist to review the case file. Number 2, the amount authorized, at least a cap for the expert services. And 3, rates authorized for the expert services. So beautiful. So if she needs A forensic pathologist, this is the cap, this is what the rates that can be authorized for the expert services, and put that in her motions and have it um, before it can be ordered. She needs to have all of the information gathered in her motions. Or number 15, the defendant has the burden to show the particularized need for each expert witness. Defendant needs to show the services of the expert is necessary for the defense of the case. So perhaps she does hire this pathologist, and she wants them to review his injuries, specifically Jorge's injuries, and why it's important, because she believes that he may have lost his life due to um, her defense is, she didn't, it wasn't intentional. She gave him the ability to get out, blah, blah, blah. So maybe somebody a bioengineer or somebody who maybe could say how he fit in the suitcase, number one, and two, how he could have been, if he could have been able to unzip it. That's a better example, biomechanical engineer or somebody like that who could figure that out based on Jorge's weight and size and all that, the size of the suitcase. All right, number 16, as enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish one, the particularized need for the due process services, and two, prejudice arising from the denial of the due process services. So, um, what's the need for it? And if you don't get that particular expert or the money for this particular thing that you're asking for, how does that prejudice your case? How does that make your case unfair? Number 17, the determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant, I'm getting better, must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of expert assistance would result in a fundamentally unfair trial. Basically, that's the same thing. Why do you need them, and why would not having them hurt your case? Costs for ordinary witnesses. The defendant will need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated costs associated with those witnesses. Yeah, like, well, okay, you want to call your mom, but why do you need to pay your mom? Like, she lives down the street. So you need to tell us why mom needs assistance. Maybe she needs medical assistance or assistance to leave the house. I don't know. Something along those lines. So you need to give us a good ass reason for that money. All right, requirement for JAC due process contract. 19, if any providers desire payment direct, the JAC procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. 20. Because of the unusual circumstances presented in this matter, JAC requests to participate in the hearing set on August 5th, 2024. JAC requests to appear through communications equipment and can be reached toll-free. So they want to be present at upcoming hearings. The one that was just set, the one that we're going to go over in part 2, they wanted to be a part of it, and they're going to be on the Zoom feed or whatever feed that they use for their online court. All right, so wherefore the JAC requests, should the court grant the defendant's motions, also include in its orders the specific due process services authorized as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by Florida statutes and the JAC policies and procedures. So many words in these sentences. That is the response to Sarah Boone from the JAC's standpoint. So now we wait to hear back from the court, from the judge, who will give us the um, potentially, if it's granted or not, if she is going to be allowed all of the costs that she's asking for. If so, does she have limitations? All of those things. So he's going to probably lay that out better in an order, but she might not. She may need to get back with more information for the judge to do an order. I'm not exactly sure, but it seems like she has work to do to get more. She needs to obtain more information before she can have those depots and things take place. So at least everybody's working on it. It seems like it's being making progress at least. Whereas in the past, we didn't know that it was making progress. But in this standpoint, the we know the files are coming. We just know it's going to take some time to get the thumb drives to her. And in this case, we know funds are coming. It's just going to take a little while for her to go through the process and figure out what she needs in order to get the order granted by the court. So that's kind of where we stand right now. Like I said, in part two, we're going to go over her motion for a what is it? Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of the criminal case for trial. We're going to read through some of that. It's a 29-page document. A lot of it is her just reiterating case law and stuff like that, which we've seen her do in past motions, so we don't have to go through the whole thing. And then we're going to go over the trial, or I'm sorry, the hearing. It's a rewatch of the hearing from, like I said, Monday of this week. So this is coming out today, August 6th. Tomorrow, August 7th, which is my boyfriend's birthday. Happy birthday. We're going to I'll put out episode 2. So definitely be sure that you are subscribed. Make sure the notification bell is on. Hit the like button on your way out, and I will see you guys in the next one. Thank you so much for watching. Take care. Bye now.